Hello and welcome to the Herrington Carmichael Employment Law Update for November 2018. My name is Alistair MacArthur, I'm the head of the employment team with Herrington Carmichael, and as always I've got the latest 4 key areas of the world of employment law to bring to you. So where do we start? We start in the world of discrimination arising from disability, and the case involving University of Edinburgh that was publicised this month. In this case, the Employment Appeal Tribunal said that it's not a simple test of because of a disability that is applied in these circumstances. It's a much broader test that the courts or the tribunals will look at to determine whether discrimination is arising from a disability. In this case, the lady was dismissed because she refused to return to the same role she had been doing following a period of sickness absence. That was sufficient to be discrimination arising from disability, and the employer would have to justify that. So in this scenario, what do employers need to be careful of? You need to be careful of the reasons you're relying upon to dismiss employees and make sure it's clear that it's not discriminatory. As always, we're available to assist and we'd recommend you take legal advice. Second case. This is the case of Timis and Osmov. In this case, we have a situation involving detriment arising from whistleblowing. This is an important case because it extends the potential respondents to a claim to not just being the business but also the decision makers. And in this scenario what you can find is that claimants could potentially pursue the business as well as the managers involved. Potential liability for the managers involved as well. One to be very careful of, and one to make sure that if you are involved in a whistleblowing situation that you're clear as to what is taking place and make sure it's not detrimental. Next, I have 2 cases which we've reported on previously and have gone up through the courts and the decisions are being confirmed. So in the case of Bellman and Northampton, this is a case involving a situation which arose at a Christmas party, and the Christmas party went on into the early hours, and unfortunately an employee suffered some quite horrific injuries. In this scenario, liability was extended for the employer into the Christmas party and beyond because it was closely connected to the employment. What does this tell us? It tells us you need to be really careful in terms of the instructions you give to your employees at social events and being clear that you are not permitted to engage in particular activities, but you could still be potentially liable in those circumstances. Care needs to be taken. Finally, the Morrison's case involving data breaches. This is one you will remember, it has been in the press, and this relates to a situation where claimants were able to pursue claims in relation to their data breach, and Morrison's were liable notwithstanding the fact that the behaviour by the employee had been potentially criminal. What this means is that employers need to be very careful in relation to data breaches, make sure employees are properly briefed in relation to what they are required to do. And although the liability for Morrison's was quite substantial here, this was under the old law. It wasn't under the new GDPR law that came in place in May, and as always we'd recommend that you carefully review your data policies and are clear as to what is required. That's it from me this month. I hope you have a very good November, and I'll be back in December. Thank you.